In this video, we are going to explore hotel liability for guest property from common law through today. The third course of law in the United States is common law. This consists of legal rules that have evolved not from statutes but from decisions of judges and also from customs and practices that obtain their authority from the test of time. Historically, this body of law was called common law because it was intended to be common or uniform throughout the country. Common law has been modified gradually as habits have changed and as new inventions have created new wants, conveniences, and methods of doing business. Since common law is based on previous decisions made about a situation or similar, over time precedents are created that laws, rules, and regulations are based off of. Beginning in the 18th and 19th centuries, people were not traveling at the capacity we see today. Originally, establishments were held liable for all of the guest property during this time when traveling was being introduced. At the time, employees of the hotels and inns were often the ones stealing a guest property, hence why common law stated the hotel was fully liable. However, over time, common law has adapted as the hotel and travel industry has changed. The liability of the innkeeper for losses has lessened over time. Whereas the law long ago imposed full responsibility on the innkeeper for personal property stolen from the premises, states today have chosen to relieve the hotelier of a significant portion of that liability. From being liable for everything a guest owned, unless an act of God, public enemy, or by negligence of the guest, it adapted to the guest having to let the innkeeper know of their possessions and could place them with the innkeeper. If the guest chose not to leave their valuables with the innkeeper, then that was the guest's choice, and if anything happened, it was their negligence. Generally, an innkeeper under the common law doctrine of infra hospitium is strictly liable for loss or damage to a guest property unless the property is lost or destroyed by an act of God, public enemy, or by the fault of the guest, or from some irresistible force other than the act of God, or from an inevitable accident without fault by the innkeeper. As time passed, innkeepers in hotels only became liable for the guest property when it was within the hotel's walls or the care possession of the hotel employee. Common law is where hotel liability started, keeping the innkeeper liable for all of the guest property that was brought into the hotel. This was considered strict liability. This doctrine was called absolute or strict liability and applied to guest property that was infra hospitium, literally meaning within the inn. Thus, if property was stolen or otherwise disappeared from the hotel, the innkeeper was liable to reimburse the guests, even if the innkeeper did nothing wrong. As mentioned, strict liability was created centuries ago when innkeepers were often the ones responsible for guest property going missing. Since then, the reputation of the innkeeper has improved and the rule of strict liability has been adapted to meet those changes. The only exceptions were as stated above: acts of God, public enemy, or by their own fault/negligence. Now, moving more towards present day, there are other practices in place. Now, hotels and inns do not solely fall under strict liability in common law, but rather there are modern statutes that protect the inn and the guests in each situation. Safes are now in rooms for the guests to use, and signs are posted about the hotel's liability limits. Guests would now have to prove something happened due to the hotel's negligence, since hotels no longer assume the role of sole insurer of a guest property once they enter their establishment. Since safes are now placed in rooms as a suggestion for guests to use in order to protect their valuables, if they choose not to use the safe, then it is the same as previously stated. If something happened and they had chosen not to use the safety measures given, then it was their choice and their own negligence. In other words, an innkeeper is liable for the loss of or damage to a guest's goods when they are being transported to or from the inn at his or her request. This applies to valet parking, valet laundry, luggage deposit, and anything an inn might carry the guest bags and items to their room for them. Common law liability states that the hotel is in essence an insurer and is responsible for the loss unless it can show the guest was negligent or an act of God or an act of common or public enemy caused the loss. Statutory liability, sometimes referred to as a limiting liability statute, has been created in most jurisdictions to limit common law liability for hotels. Hotels and inns have moved from strict liability under common law to limiting liability statute. Note that many hotels post a policy describing their limitations of liability for property and providing an in-room safe or a safe at the front desk for valuables. Assuming the posting is reasonable, this can limit the liability to what is stolen from the safe, not what is simply left out in the room, unless negligence was shown by the innkeeper in selection of employees, etc. In addition, if a hotel chooses not to comply with the statutes in place and guests are not notified or provided proper safety measures, i.e., safes, vaults, signs, etc., then the hotel risks being liable for all the guest belongings because that would be negligence from the hotel. However, to receive the protection of the limiting liability statute, management must do the following: provide safes that withstand fire and theft, either in rooms or in a central location; post notices that safes are available for guests to use; post notices of that state's maximum monetary limit of liability; require guests to declare the value of goods at the time of surrender if the statute's statutory if the state's statutory limit is to be exceeded. If any of these statutory requirements are not met, the hotel might not be afforded the protections of the statutory limit of liability. As a result, hotel liability could possibly exceed established limits through the application of common law standards. Bringing us to modern day hotel liability, for the most part, a hotel is now only liable once the guest checks in and for the length of their stay. Once the guest checks out, the hotel releases all liability of the guest property at this time. The innkeeper-guest relationship comes to an end when the guest pays the bill and checks out of the hotel. However, there are a few exceptions for when this policy changes. If a guest chooses to put their belongings in storage for a time after the bill has been paid, the innkeeper is now liable for all items in their possession until the guests choose to pick up their belongings. To summarize, in the 18th and 19th centuries, when hotels, motels, inns, bed and breakfasts became more popular, innkeepers were often known for being the ones to steal a guest's property, causing them to fall under the old common law of absolute or strict liability. This made them liable for all of a guest's property, meaning anything the guests brought with them to the hotel, because they were often the cause of a guest's property disappearing. Under the common law, the liability of the hotel keeper covered whatever the property the guest brought into the hotel. It was not limited to baggage and wearing apparel or to goods of any particular kind or amount. However, over the centuries, as travel increased, hotel liability had to change as well. The hotel would now only be liable if a guest can prove the hotel's negligence regarding the loss of their property when it was at the hotel or in the hotel's possession. As mentioned, hotels got bigger, the amount of people traveling increased, therefore laws and statutes had to be reevaluated. Current law recognizes that the absolute liability rule is unnecessarily burdensome to modern-day hotels and innkeepers. All state legislatures have adopted statutes to limit significantly hotel keepers' liability for guest property losses, provided the hotels follow specific procedures. This is an example of when legal rules started to change due to the increase in volume of travelers.